21-36805 is called. The State of Texas versus Louise Kenlaw. That is you, Mr. President, with Mr. Dusler, your attorney and the state's attorney. Does the defendant waive a formal reading of this motion to revoke probation, which was filed on April 12th?
Already, we're seeing how technical details can flip a case. Just a county name correction could have been a loophole. This shows how precise the legal system has to be. Imagine losing a case over a typo.
Of 2024, can we proceed in assembly?
Yes, sir, but I think the state needs to amend counts 1 and 2 of the motion.
That's correct, Judge.
Mr. Kenlaw, raise your right hand. Do you solemnly swear or affirm any statement you make during this hearing shall be the truth, the whole truth, and nothing but the truth? Okay, lower your hand. Yes, go ahead.
Counts 1 and 2,
Counts 1 and 2.
There's a reference that his offense occurred in Chambers County. In fact, it occurred in Orange County.
Anthony Robbins.
So allegations 1 and 2 should reflect Orange County rather than Chambers County.
That's correct, Judge.
Any objection to that?
No, sir.
And that's what the defense understands is correct.
That is correct. And those are the counts he's going to be pleading truth to as well.
That is changed and corrected to allegation 1 here.
This is a big deal. By pleading true to violating probation, he's basically handing the judge the keys to lock him up. No trial needed, no jury, just straight to sentencing. Brutal but efficient.
States that you committed the offense of operating a motor vehicle while intoxicated with a child under 15 years of age on or about March 10th, 2024 in Orange County, Texas, in violation of condition 1 of your probation order, which is don't commit an offense. Is that allegation true or untrue?
So,
Number 2 states you committed the offense of abandoning or endangering a child on or about March 10th, 2024 in Orange County, Texas, against the peace of the state, also in violation of condition 1 of your probation order. Is that true and correct?
so
Are you pleading true and correct to allegations 1 and 2 voluntarily? No, intelligently, and because those allegations are true. Do you understand that a knowing and voluntary plea of truth or more violations of probation, that is enough to grant the motion to revoke probation? Your probation can be revoked. You can now be found stand by. You were under probation, so your probation could be revoked and you could be sentenced to no less than 2 nor more than 5 years confinement in prison. In brief, you insist on pleading true.
Here comes a hammer. Judges don't just look at the crime, they look at the pattern. And when kids are involved, the stakes shoot through the roof. Notice how the judge zeroes in on the child endangerment angle.
So I find you pleading true voluntarily. You understand and appreciate the consequences of pleading truth. This is, I agree, stand. You got a copy of this probable cause affidavit that's in tiny print.
Judge, I blame the probation officer.
Well, intoxication has been kind of your problem, hasn't it? On a bunch of different things here. You were on probation because a child was in jeopardy, and then now we've got some other allegations here. Okay, go ahead.
well, he absolutely recognizes that alcoholism is a problem. And he wants to address that problem. And in fact, he has voluntarily submitted himself to substance abuse classes. He has a certificate we'll present to the court showing that he's completed a substance abuse program to try to address that problem. He knows that that's a problem that's going to continue, that he's got to still deal with it the rest of his life. And he really believes if the court would continue him on probation.
Where was this conducted and completed? At the state jail, when you're at the state jail.
Yes. And he actually served 15 months in state jail because of the Orange County offenses I mentioned in the motion to revoke. But what he and I have discussed, and he feels like that if the court would continue him on probation, it would force him to be monitored to where he can continue his substance abuse treatment. Hopefully,
look at that clash. The defense is begging for mercy, but the judge is basically saying, I already gave you mercy and you blew it. How many lifelines should someone get? What do you think? Should repeat offenders still get another shot?
This problem that he's had with alcohol, and by the time that probation's over with, he'd be clean and be able to keep clean. He can do it on his own, but I think he's got a better shot of doing it when he's under supervision. And that's what he's asking the court to do, is consider keeping him on probation where you can monitor him.
Are you still on parole, though? Are you on parole for that state jail?
No, no, was on parole.
He received a full 15 months, which he served. So in essence, what he's asking for is consider that as his punishment and give him a second chance. The state is in
How long, though? Is that what you're saying?
Sure.
Well, I gave you a second chance when I put you on probation, July 28th, 2022. How many chances does someone get?
First of all, I didn't kill nobody.
Thank God. I thank the Creator, not you.
Yeah, I work for a living. Every time I came in front of y'all, I always had a job. I don't lie, I don't steal, I don't kill, so, yeah.
But you've had a consistent pattern here now of putting children in harm's way. Anything wrong? Do you see anything wrong with that? That's terrible. You know I
It
do.
was only one time. First time through my probation, they didn't involve me.
How many times is 2 minutes? You got to agree. A child put in jeopardy because of your having that's
I was put on probation, I was still in my addiction.
probation, and it's kind of disappointing to me here because we have a 92% success rate, and we're real proud of it on probation. 92%. I hate to see. I brag about it when I'm speaking at functions, and we're very proud of that because the national average is 75.
Right.
And we have a high rate of probation success, but it's because our probation officers are good. But you got to carry your own weight like always. You got to do some of the swimming here and the rowing. And
That's why I actually,
this was kind of disappointing. You were sentenced the first time. What were you in the state jail for?
He was in state jail for those offenses, Judge.
That he just pleaded
yes, sir.
guilty.
Yes.
Okay.
If I may, Your Honor.
Was it out of this court?
5 felonies on the record. At this point, the state's painting him as a career criminal, and the prosecutor slips in a subtle jab. We trusted him once, and look what happened. Classic courtroom strategy. Stack the past to bury the present.
No, sir. That was out of Orange County. That's why he pled true to it. He knows that he's guilty of it. When this man appeared before you,
Does he have credit, please? Go ahead.
he's got about 220 days credit, is what we know, Judge. When we appeared in front of you, Your Honor, in 2022, there was a cap agreement of 5 years, and I argued for the 5-year TDC time because of the assault on a peace officer that Your Honor made the choice, listened to his defense counsel make a really good argument that he needed some help, and we gave him an opportunity to be put on probation, despite the fact that he had 3 felony convictions before that sentence date. So now he stands here with 5 felony convictions, asking Your Honor for another opportunity. As you know, I don't agree with that. Had we sentenced him then, he wouldn't have had a new offense. Now, that's not me chastising the court. Your Honor is always really good about giving people an opportunity. Certainly saw that he could succeed. And in fact, the probation officer told me he was really doing well up until he committed this new offense. The problem is he only made about 15 months. And then he gets sent to state jail for another 15 months. If Your Honor does give him the opportunity, it's not one that I'm in agreement with.
Opportunity, what do you mean?
He's
Back
asking.
on probation?
I just don't agree with it. I'm asking for 5 years, Judge.
Okay. Yeah, you get to say something. Go ahead.
before this, I never took a alcohol anonymous class. I never had help by alcohol. I understand you gave me probation,
Well, I kind of stuck my neck out.
you know, I needed more help than that, and I got it once I went to state jail.
Okay.
I was around other people that had addictions. We was able to help one another. I never had an alcohol class, so that was my first time taking it. All I'm asking is, can I continue to take it?
Sir?
All I'm asking is, can I continue to take it, continue to help?
There's nothing to stop you from continuing to do it on your own, but how many chances do you get? I don't open the door for you, I open it for everybody else. You were put on probation already. You failed. How many? I know the answer to it. I just, you know, it's your life. No one knows better than your life. How many misdemeanors do you have and how many felonies?
And there it is, the gavel drops. Probation revoked. for years in state prison. Notice how quick and final it feels? After all that back and forth, the system moves like a guillotine once a decision is made.
How many convictions do you have?
Well, felonies probably 3 or 4, and misdemeanors 2,
3. 3 and 3.
3.
No, 6. But the point being is that you don't know for sure. You've heard something about your own life.
It's a long time ago.
I know. But it's not something like that should never be in the past, because it should be in something that was important that you remember. But it had been a while. You're right. But the drinking problem is a problem. All right. Anything else to add?
No, sir, we have nothing.
If nothing,
I think he's expressed to me.
If nothing further, there is sufficient evidence supporting this motion to give both probation to grant it at the preponderance of the evidence. We're working up here, folks. Thank you. As allegation 1 and 2, correct, have been proven.
Yes.
As the defendant has pleaded true, voluntarily, knowingly, intelligently to those allegations. And that is enough to grant this motion to revoke probation by a preponderance of the evidence or greater. Your probation is hereby revoked, sir. And you are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 4 years. You'll be given credit for all time that you have served in connection with that. And this is yours. So I don't know if you'll be released immediately or if you're going to have to stay in a little longer, but fix all this mess, sir. Anything else?
No.
That is all. Thank you. And we call 25 CR 140, the state of Texas versus Gregory Linnell Johnson. You are Mr. Johnson.
Yes, sir.
Present with your attorney, Mr. Weston, the state's attorney does the defendant waive a formal reading of the indictment and the arraignment here. Can we proceed summary?
Yes, sir.
In summary, this indictment alleges that on or about September 30th, 2024, in Jefferson County, Texas, you committed the state jail felony of theft of property. Do you understand what you are charged with?
Yes, sir.
If convicted, it's a state jail felony, which means you face a term of not less than 180 days or more than 2 years. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement has been reached. In your case, you would be pleading guilty, sentenced to 2, I guess that's years. There's nothing at years, 2
I guess I'm sorry.
in the state jail. That would be suspended. You would be placed on regular probation, 5 years. And among other things, you would be sent to substance abuse felony punishment facility to help you as a term of probation.
Yes, sir.
Is that your understanding of the plan?
Say yes, sir.
If I follow this, you have no right of appeal of your case. Do you understand?
Say yes, sir.
How do you plead to this, guilty or not guilty, sir? Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
I'm going to show you what's marked as State's Exhibit 1 after your attorney signs the right documents. Patient on that.
I did have it.
Did you sign that document voluntarily? Did you understand it, discuss it with your attorney?
Yes.
Are the contents true and correct? Yes.
Yes, sir.
State's Exhibit 1 is tendered into evidence.
No objection.
And without objection, it is admitted. Among other things, this states you are mentally competent to enter your guilty plea, which is really involuntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged and any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer. All of this is true. It states so help you God.
Yes, sir.
State's Exhibit 1 is part of the record for all purposes. Pre-sentence report is waived.
Yes, please.
I'm going to follow this agreement, if nothing further, and find you were pleading guilty voluntarily and you were mentally competent to do so. You understand and appreciate the consequences of pleading guilty, and there's sufficient evidence supporting your guilty plea. From State's Exhibit 1, admitted here to find you guilty beyond a reasonable doubt, and I now find you guilty beyond a reasonable doubt of this state jail felony of theft. I am following this agreement. You were hereby sentenced to confinement in the state jail for 2 years. That is suspended, though, and you will be placed on regular probation for 5 years. You will attend a substance abuse felony punishment facility and be required to complete that. Is there any restitution here?
No, Your Honor.
No restitution. There will be terms and conditions of probation, which are normal and customary for this type of offense. Make sure you follow these. If you don't, your probation could be revoked and you could be sentenced up to 2 years in the state jail. We don't want that, but we want success. You understand what has happened today, Mr. Johnson?
Say yes, sir.
I can sign this, and you'll see this man and begin probation.
Revoked him on the one that he had the new offense for, or the
All right, this is 24 CR 349 manslaughter, second degree felony,
right.
and this was indicted a year and a half ago.
Yeah, well, he was revoked, Your Honor, and sent off to TC.
When did you get released?
April 4th.
Right.